General Sauer, if you're correct that courts do not have the authority to reinstate a removed officer, why are we wasting our time wondering if there's cause or not? I mean, because even if we say, yes, there is cause, shouldn't have removed her, but we don't have the authority to order her reinstatement. How is that consistent with the time and energy being spent on determining if there's cause?
We agree that that's an alternative basis. As we say in our brief, that's reason enough to rule in our favor, and we have a holding of the court, Sauer. We also have this tradition I was referring to earlier of recognition that runs from the decision of 1789 to all the opinions in Myers, it's alluded to in Wiener and so forth, recognizing the president's power of interim or suspensory removals. So we agree that's an alternative, that's an independent basis for us to prevail.
Well, it's an independent basis. I guess it's not independent in the sense that if that's right, the other one is irrelevant, right? It seems to me that if there is any level of cause, and you indicate that there is some level of cause, right, well, then you can't be right about the idea that courts can't order anybody who's been removed to be reinstated.
There is a traditional remedy to reinstate, we don't dispute, there's a traditional remedy to reinstate wrongfully removed officers, which is mandamus. But they don't argue mandamus here, and the reason they don't argue mandamus is they face a number of insuperable obstacles to prevailing in mandamus. One is, of course, going all the way back to Marbury against Madison. You can't mandamus the president, his discretionary acts. In addition to that, there is no preliminary writ of mandamus, as Judge Friendly pointed out and the Seventh Circuit has held. In other words, and keep in mind that the standard in mandamus would be clear and indisputable right to relief. And in fact, this is an ultra vires challenge where the standard is exactly the opposite.
So there's a circumstance in which a court can order the reinstatement of a wrongly removed officer.
But there is a traditional remedy, mandamus. Here, obviously, it'd be quo warranto if there were two competing claimants, but where there's just the one, that would be mandamus. And they have not argued mandamus. They're trying to find their way around mandamus because the standards to prevail under mandamus are insuperable, and they clearly cannot meet them.